threats on his life. Because of that, he has always previously testified wearing things to conceal his identity would allow his eyes to be seen. So the state is requesting for him to be able to wear that, to be able to hide things of his identity that aren't easily changeable, so as to protect his safety.
And that's the purpose that you gave me this case? It says something to that in here? I haven't read it.
No, that is on a different issue. That was provided to defense counsel as well yesterday. There's been a discussion as to if they were going to stipulate to a portion of what the state would have to prove, or if the state was going to have to be able to get into all of the other areas regarding the gang affiliations and the other crimes committed by other gang members, which is what the case I provided to Your Honor states. That the state does have to prove multiple members and that they are also committed and engaging in criminal acts.
And what authority would I have? Is there some case law that was happened before?
For Detective Polo to testify as such?
Yes.
He has testified twice in Judge Uson's courtroom wearing this same headgear in the case of the state of Florida versus
No, I was asking if there was any appellate cases.
I have not seen any, Your Honor, on this specific issue. He's testified before Judge Fine just last week wearing the same headgear in State of Florida versus Scott Peterson. The other one is State of Florida versus Trayvon Newsom. There's 3 other co-defendants as well on that case.
Well, Judge, first of all, regarding that, I would like to see the outfit that he is supposedly going to wear to disguise himself. It's a violation of the Confrontation Clause of the U.S. Constitution. And the state should have, with all due respect, filed a motion giving us notice of that prior to bringing it up. Concerning that, there are several issues concerning that. And the Confrontation Clause deals with the demeanor of the witness.
Can I stop you for a second?
Huh?
Can I stop you for a second?
Yes.
Regarding this particular witness, did you take his deposition?
We did take this step.
And was he wearing a mask then or not?
Yes, sir.
He was, but
So let me stop. I'm just trying to figure out, is this the same type of mask that he wore then he's going to wear now?
Yes, sir.
I think the court needs to see it because it covers his entire face other than his eyes. So the jury cannot see and observe his demeanor at all. At all.
I understand the court only wants to hear arguments.
No, I was trying to figure, counsel said he wants to see what it was.
I really want the court to see it.
That's why I want to know if he took his deposition, if he's wearing a mask during the deposition.
I just wanted to clarify 2 things. Mr. Edelstein is making the argument. One is that the record is clear that none of the threats that this witness, that were referred to by the state concerning this witness, have anything to do with this defendant or this case. The other is to clarify that the state did not file a motion, but the state did give me notice yesterday evening. They raised the fact that this issue would be raised.
If I may approach, Your Honor, this is a photograph from...
I'd ask that you print that out and mark it as an exhibit.
I can't print it in color in the courtroom, but I'm happy that's a June 12th photo from the Broward County Courthouse where Detective Polo was testifying in a different case.
All right, anything else?
Yeah, can we approach the bench for a moment?
Sure.
Yes, sir. Please state your full legal name for the record. Danny Polo. Please spell your first and last name for the record. D-A-N-N-Y-P-O-L-O. Thank you, sir.
Thank you. And please have a seat.
Thank you.
Detective Polo, what's happened is you're wearing a mask now. Defendants have objected to that.
Yes, sir.
And the state indicated that it's been done in other courtrooms and there's a predicate for it. I guess because of safety and security is the way I understand, specifically your safety and security.
Yes, sir.
Is that correct, madam?
Yes, Your Honor.
So I want you to come in here, I want to take some testimony from you outside the presence of the jury just to verify all of this. So, Ms. Bradley, I want to inquire.
Detective Polo, how are you so employed?
With the Broward County Sheriff's Office
How long have you worked for Broward County Sheriff's Office?
since 2015.
How long have you been assigned to the Strategic Investigations Division?
Since March of 2018.
In your time in the Strategic Investigations Division, or SAD, have you worked undercover operations?
Since that time and before.
And the undercover operations that you work, what type are they?
Majority of them are narcotics, firearms, violent crimes, gang-related investigations.
How many years did you spend specifically in the gang and organized crime section of the Strategic Investigations Division?
From March of 2018 till 3 weeks ago.
Have there been credible threats on your life?
Yes.
Is there currently a credible threat on your life?
Yes.
In terms of is there an amount of money assigned to the death of you that has been offered up?
Approximately $50,000.
In terms of your safety and security, why do you wear the mask for those reasons?
To protect my family. So I'm not walking around Broward County, Palm Beach County, Dade County, anywhere, and get ambushed by someone that might be looking for me. We've done cell phone warrants on multiple people in Broward County involved in the investigation where I got the threat. And outside of that investigation, there's photographs of deputies being sent around, people trying to figure out who I am and what I look like. And that's a kind of a concern for me. If it was just one person, I'd probably just write it off. But yeah, after 5 or 6 cell phones got downloaded, and there was pictures of many deputies being sent around saying, "Is this Danny Polo?" I'm like, okay, these guys are actually looking for me.
And so, Detective Polo, with regards to the prior times you testified in court, did you testify earlier this month before the Honorable Judge Martin Fine?
Yes.
How were you attired?
I believe I was wearing this suit probably.
And in terms of your face, how was that done?
Same mask.
Have you testified before the Honorable Judge Michael Usan in this courthouse?
Yes.
Was that in or around February and March of this year, 2023?
Yes.
And what case was that on?
That was the XXX Tentacion case.
And that was the death of that individual?
Yes.
How many times did you testify in that case?
It was twice.
How were you attired when you testified then?
Different suit, same mask.
And in terms of during that particular testimony, were individuals trying to call your cell phone and get in contact with you during the actual testimony?
Yeah, that happened.
And was this testimony live streamed as well?
It was live streamed.
Okay. Thank you, Your Honor.
You have any questions
Yes,
on this issue? Go ahead.
yes. What time did you get to the courthouse today and sit outside?
Just after 9 o'clock.
And were you wearing that mask?
No, sir.
In fact, you've been sitting out there for at least an hour unmasked as people were walking in and out, correct?
Correct.
Are you the only expert in dealing with gangs in DSO?
I believe I'm the only one that's testified as an expert at the Broward Sheriff's Office currently.
How about in the state of Florida? You know?
I'm sure there's other experts in the state of Florida.
And for the last hour, you've been right outside this courtroom where the doors are, correct?
Yes.
Unmasked,
Yes.
as people in this group, including myself, were walking in and out, correct?
Yes, sir.
You weren't concerned about your safety then?
No one knows who I was out there. And I was under the impression I wasn't going to be allowed to wear the mask. So I took that one on the chin.
I have no further questions.
Thank you. So, detective or deputy, I'm sorry, which is it?
Detective Deputy.
Regarding, you're telling me that you have fear for your safety.
For my safety, but more for the safety of my family.
And that's if you're faced with broadcast.
Yes, sir.
And you're indicating now that there is intelligence from BSO that there is some type of bounty or price on your life.
I intercepted it on a court-authorized wiretap through the state of through Broward County. It was a wire authorized by Judge Siegel. We had a gang investigation. During that investigation, there was conversations about placing a bounty on my head, upwards of $50,000. And since then, we've, as I stated before, recovered several cell phones in that investigation, other narcotics investigations, firearms investigations, an investigation in South Carolina that is tied to Broward, where photographs of deputies were sent with my name attached to it. People trying to figure out who I am, what I look like.
Thank you, sir.
Thank you, sir.
Can you step down just way outside? We're in recess. Good. Defense ready to go?
Yes, sir.
All right, so a couple things. Number one is there's 3 different events, I guess, took place this morning. We started off with the complaint about the TV crew and monitoring in-trial conversations between attorney and client. Mr. Jason came up initially and indicated that the microphone was sensitive and picks up everything, and so I had told him to remove it. Then afterwards, they came back with his producer, whose name escapes me, indicated that there is a meter on the microphone that will adjust its sensitivity, and they will adjust its sensitivity so as not to pick up any discussions between counsel and client. They also indicated that they would not show the screen or take during the session have the camera pointed at defense counsel and or the defendant. That would only be as the jury is entering and leaving the courtroom. And I thought that was a acceptable compromise with the understanding that they cannot capture any of the conversations, confidential, privileged communication between the attorney and client. They indicated they would make sure that didn't happen. And they're also going to adjust the location of the microphone the way it's going. The second issue that came up was the mask, and the detective, although indicates he's a police officer detective, operates undercover. There's a bounty on his life, was picked up in wiretap communication, was feared for his safety of him and his family, and with the understanding this trial is being live streamed, I understand his fear for safety, and I understand the defendant's objection overruled. He'll be allowed to testify. This is something that I think, again, is trying to balance it, what we're doing. And my thought is that based upon the testimony of the detective, that this would be an acceptable way to proceed. And I understand it's over the defense objection. The last thing has to do with the juror who's ill. This is Ms. Claudia Calzani-Molina. And again, as I indicated, she was admitted to the hospital. I know defense counsel asked that we just wait for her and just adjourn, not be in session today, but I have no idea. This is the second hospitalization for her. She was not admitted the last time she was in the emergency room. And it was something that was, the way I understood it, dehydrated, something minor, food poisoning or something like that. But now she's admitted to the hospital because so it's a different situation. We have witnesses here. Jury's already asked us questions about how long the trial's taking and when we anticipate it's going to be resolved. So my thought is we're moving on. Ms. Claudia Calvizano Mena is going to be replaced by the alternate, whoever the first alternate is. All right? So you got your witness here?
Yes, sir. I just need to give a drive back from the defense and then let them go on to they reviewed the evidence before the witness begins testifying. I also sent copies of all of the text messages on which he's relying upon as well. And so if there are any specific instances or any other changes in terms of the testimony from the defense, if they wanted to say it provided the AK v. State case with regards to the fact that the state, as a requirement through this proceeding, has to prove that there are other individuals that are associated with a criminal street gang that are committing other such crimes. So the defense had mentioned stipulating at certain points. So before I call the witness, I want to make sure we have a final discussion before the state proceeds forward as planned.
Now, Judge, with respect to the series, I think it takes the form of 3 separate sets of exchanges. I actually think it's 4, but 2 are subsumed within one exhibit. With respect to those, we maintain our objection that it lacks the foundation to be introduced. We have presented the court with cases that for social media and text exchanges to be admitted, one party to that conversation needs to be brought in, or which is the preferable method, or there's some other method of establishing the receiver and sender, and authenticating those communications to be what the state represents them to be, or the offering party, whoever it is. So we object on those grounds: lack of foundation and hearsay.
Thank you. Well, this is a different hearsay objection. You're trying to offer them for the truth of the matter asserted?
Yes, Your Honor. In terms of that, there is case law and approach on the copy to the defense. State v. Torres 304 781. This was a case in which the Honorable Maria Garcia Wood of Broward County bench excluded text messages and was found to be an error.
And what's the theory? What's the exception to hearsay rule?
It is a statement by a party opponent. They are statements of the defendant. The other statements from the other parties involved give context to those responses from the defendant.
And concerning it being a statement of a party opponent, that's where it requires some authentication to establish that it is a statement of a party opponent. And I think the phone handle for each one of these texts is Sack Chaser Howard. Sack Chaser being the nickname, as we have indicated before, of one of the decedents. The phone is not registered in the name of our client, Mr. Demons. The phone was not retrieved.
Are these all from the download? The extraction that was done?
Yes, sir.
So you're maintaining, again, that it's not his phone. So, and that's why previously, you said it was hearsay objection. I overruled that because it goes to who's using and controlling the phone, circumstantial evidence of that. And that's why I let it in previously. If you're saying that you want to demonstrate or document that it's his phone and you're going to show some of these texts or emails, we'll see where it goes. You make your objection, we'll see where it goes.
Okay. So that was with respect to the admissibility of it. Also, I think the state is just made a comment of trying to shift to the defense the burden of establishing the relevance of that which it proposes to introduce in evidence. Instead, we have here about 200 plus pages of documents. The defense can go through and tell me what they don't want me to include. That's not how it works. They have to establish the relevance of each one of those communications in order to introduce them. So again, we take exception and object to this reversal of roles. The proponent of testimony has to establish its relevance to introduce it. The state is saying, let the defense tell us what they don't like and we'll consider taking it out. That's not how it should work. That is an ominous and unreasonable burden on the court and on the defense to go through and ferret out that which is not relevant. They have to establish its relevance. So we would respectfully request that. I think the state indicated earlier that each one of these communications has to be gone through, and that's why this witness is going to take as long as they said it's going to take. And so when they do it piecemeal, we'll be in a position to make our objections as the evidence is being adduced.
Thank you.
Thank you.
For the jury. Get your witness, please.
One more thing, Your Honor. I think the state yesterday had proposed to us the alternative of clearing the courtroom and letting this witness testify unmasked, and we think that would be much preferable to the masked situation.
Thank you. Then again, the news media has a right to be here as well. That's my concern, is you're trying to, it's just a balancing thing. I understand that was, I thought Mr. Adelstein indicated that was something that was preferable to him. I agree with him. All right, we'll move it forward.
Is the court going to give any type of curative instruction?
Excuse me 1 second. Hold on. You have some instruction on the read?
Yes, Your Honor. I think we would have to include that the court has made a determination that balancing the interests of this defendant's constitutional right to confrontation is superseded by the media's right to be in the courtroom, and therefore he's being allowed to testify in a mask because those are the two interests that are being balanced. This defendant's constitutional right to confrontation and have the jury have an opportunity to discern the credibility of the witness versus the right of the media to have a camera in the courtroom. And so we would want that to be a component of any instruction that's given to the jury, and we'd like time to craft one because the court just ruled, and we'd like to come up with one proposal.
Go ahead.
Okay. Can we have some time?
Now, counsel, you have something short and sweet. You know, you make a recommendation. I don't want this to go on for an hour. It's already 10:30.
I understand, sir, but this is extremely important, and we would ask for a 5-minute recess so we can fashion something.
Thank you.
Thank you.
Tell the jury 5 minutes. Yeah.
We have not agreed on, no.
I didn't see counsels. I have some proposed instructions that I provided, and I'll read out loud for the court. Based on the court's ruling, the next witness will testify wearing a mask. You are to listen and read evidence as you would any other witness.
Thank you. Can I see that?
Yes, Your Honor.
Yes, sir. And you have one?
We'd just like to say that would be impossible to do. Our proposed instruction is the court has ruled that the next witness will be permitted to testify with his face concealed with the exception of his eyes. The court has made this ruling because this witness has expressed that there have been threats made against his life by people unrelated to this case. Your jury instructions advise you to observe the demeanor and facial expressions of witnesses in determining their credibility. And obviously, you will not be able to do so in this case. You are committed to take the compromise of your ability to view the witness's facial expressions into account in deciding how much weight to attribute to his testimony. He is being allowed to testify in this fashion because the court has determined that the interests of the media in being present outweighs the defendant's constitutional right to face-to-face confrontation of witnesses against him.
Thank you.
That would be it.
All right, counsel, respectfully, I'm not, wouldn't be giving that instruction to the jury. All right, let's bring the jury in.